All right, if you're a sports junkie like I am, you're gonna wanna stick around and watch this video. I'm gonna go over the new laws that the Supreme Court came down with on name, image, and likeness for college athletes, okay? So name, image, and likeness is derived from two major Supreme Court cases in a row, all right? One is the NCAA versus Alston, all right? In that case, the moving parties in the case that brought the lawsuit in the lower courts, they said it was a violation of the Sherman Antitrust Act. Okay, it was anti-competitive for a college to be able to limit what a student athlete could get for educational benefits. They were only limiting it at the time to tuition. Like you could go to school for free on a scholarship if you were a Division I or a Division II athlete, and that's the limit of what your educational benefit could be, generally speaking, if you were a student athlete in a college. The Alston case made it possible for the institution to offer more educational benefits, be it computers or other types of benefits and the like that a student athlete can get from being a student athlete at the school. It's not limited. And that opened the door to the bigger case, which is House versus NCAA, okay? House versus the National Collegiate Athletic Association. And in that case is where we got name, image, and likeness. We all have seen it over the years. The biggest names in college football, which is the best example, that made their institutions, their schools, millions and millions and millions of dollars. In the 80s, it was Doug Flutie for Boston College. In the 2000s, it was Tim Tebow for Florida and Johnny Manziel for Texas A&M. These guys came through and they received zero financial benefit at all, even though they made so much money for the schools. At the times where their institutions were paying their coaches millions of dollars to coach these organizations, these teams, the guys that were doing all the work on the field were making nothing. Did they make a name for themselves? Sure. Could they benefit on that financially? Not until they got to the NFL. Is that fair? I don't think so. I'm sure many of you don't think so either. So now we have name, image, and likeness. Now, Orlando & Associates is largely a personal injury firm. That's what we focus on. That's what we specialize in. But there was a time in the 90s when Orlando & Associates, and specifically my father, Joe Orlando Sr., represented athletes. He was a sports agent. So I grew up learning all about this. And I can tell you that the system has been and continues to be flawed. Is it better now? Yes. Is it great? No. So what do we know? Name, image, and likeness. Back before name, image, and likeness, before House versus NCAA, student athletes would be used on advertisements for college football games, college basketball games, hockey, whatever sport. And the school would benefit from that. The TV stations that carried the games would benefit from that. Everyone would make a lot of money, except that student athlete would only be limited to their education for that benefit. Now, does that have value? Sure. It certainly has value to get an education. But is it really the value that the student athlete brought to the institution or to the TV stations or other advertisers? No. So why would it be fair for everyone to make money and not for the student athlete? I submit to you that it isn't. Now, the Sherman Antitrust Act is a very old law, okay? It made Standard Oil and John Rockefeller and the titans of industry of the day break up their trusts at the time so that they had a more competitive market and they didn't have 90%, 100% of the market in any given product or service. And it worked. The Sherman Antitrust Act created a competitive environment which helped consumers because it drove the prices down. That was the point of the Sherman Antitrust Act. And that act, that requirement for competition in the market, is what brought NCAA versus Alston and House versus NCAA cases to the Supreme Court. And the Supreme Court, which only really gets a lot of press when they're dealing with some sort of a national social issue that's very divisive, and you always see that they vote 5-4 or 6-3 or something close on some issue. What you don't really know is that the Supreme Court votes 9-0 more often than they vote along similar 5-4, 6-3 lines. And in this case, in a unanimous decision, the Supreme Court said it's unfair, it's anti-competitive under the Sherman Antitrust Act for a student athlete not to be able to benefit from their own name, image, and likeness. What does that mean? Your name, we all know what your own name is. Should a school be able to use Johnny Manziel's name or Tim Tebow's name to advertise and to bring in revenue and advertising dollars and other monies, but not benefit Tim Tebow? That's the premise, okay? And that's the example I'm using here. And of course, at the time, Tim Tebow could not benefit. Johnny Manziel, Johnny Football, could not benefit. In fact, Johnny Manziel famously got in trouble for taking $30,000 to sign autographs when he was just using his own name to sign that autograph. If he were playing football in today's day and age, he'd be swimming in money. And maybe he did at the time, I don't really know. But I can tell you that at the time, the rules were that he wasn't allowed to, and that's not fair. So now a student athlete can benefit on their name, image, and likeness. A school, and there's limits on it, can pay a certain amount of revenue that they get, a certain percentage, a certain amount, to a student athlete as a benefit. Now, that allows institutions to recruit better. It allows different schools to compete for student athletes. It created a more competitive marketplace, and it allowed for a student to benefit off of their own work, their own body of work on the field, their own name, image, and likeness. Now, if a picture of you was used for an advertisement, I think you'd want to benefit from that, or you wouldn't want them to use it. That basic premise is where we start. So now student athletes can get hundreds of thousands, if not millions of dollars from the institutions that they go to as a revenue share as a result of the famous Supreme Court case that now has come down, House versus NCAA. What used to happen is almost inexcusable. Although the settlement of $2.8 billion did get paid out to former student athletes, it is very doubtful that that settlement was able to really compensate some of these bigger names for what they lost. And it's really scary because in a game like football, you might get injured in your junior or senior year in football and never be able to play in the NFL where you'd make your money. And that whole time the school was making money off of you and you weren't getting paid. That is just simply unfair. So, name, image, and likeness. It's a whole new world in college sports. Some may argue that college athletes have now become professional athletes because they're making money off of their body of work on the field. And I know that we like to think of college sports as a place where, amateur athletes come and they compete for the love of the game, etc. And that's fine until money was introduced into college sports decades ago and everybody made money but the students. Then it became really unfair. I represent employees in my work as a personal injury attorney. We represent employees that are injured at work. That's workers' comp cases. We represent a lot of employees when there's a breach of an employment contract. We've certainly handled those types of cases as well. But in the 90s, Orlando and Associates actually had a division that represented athletes. Most famously, the 1992 bronze medalist in the 100-meter dash in Barcelona Olympics, who later signed a deal as a wide receiver in the NFL and a kick returner. And that type of environment was much more difficult for amateur athletes. College athletes at the time, they were lucky if they got a scholarship to a big institution that paid for their education. That was the limit of their benefit. If they took a dinner out with an alum or a suit for an interview or signed autographs for a few bucks to try to get through school. We all know college students don't have a lot of money in their pocket. That type of thing would get them in big trouble. They could lose their one benefit they had, their scholarship, if they were caught doing those types of things. And I'm sure there was a lot of funny business from a lot of these schools and a lot of end arounds and workarounds to try to make sure the student athletes were taken care of so they were happy and they stayed at the institution. But in today's day and age, with name, image, and likeness money available to student athletes, and with the transfer portal in place so that student athletes can more freely move between institutions without taking years off, etc., before they play at the next school if they're unhappy in their current environment, that type of environment creates an almost free agency that's similar to professional sports. And that's something that Orlando Associates dealt with quite frequently at the time, both in baseball and football and basketball and other sports, and in multiple countries. Now, what's really interesting about the name, image, likeness rules is that while the Supreme Court issued a federal case precedent that said that student athletes can benefit from their name, from their image, from their likeness, they can make appearances, they can do advertisements, they can do endorsements, there's things they can do. Every state has their own rules about what those student athletes can do. So that's going to create a very peculiar thing that each state legislature is going to have to deal with, or maybe even the state court systems are going to have to deal with if it doesn't match up with the federal law and the federal case precedent. So what we're going to see is a flurry of lawsuits and cases that are going to set precedent unless each of these state legislatures or Congress at the federal level act on this issue. And it's a major issue. College sports is a big business, and now it just got bigger. I'd love to do more of these videos about sports and other things. A lot of people ask me questions about name, image, and likeness when it became really popular a couple of years ago. And if you have questions or if you have idea topics that you want to cover, send them in to me. We'll do some live videos too, and we'll talk all about sports and law and have the two areas that I love in this world combined.